Welcome to USDA NIFA's Civil Rights Laws Overview Training. My name is Jessica Creighton, and I am the Senior Equal Opportunity Specialist with USDA NIFA. Before we get started, please be aware that in accordance with federal civil rights law and U.S. Department of Agriculture civil rights regulations and policies, USDA, its mission areas, agencies, staff offices, employees, and institutions participating in or administering USDA programs are prohibited from discriminating based on race, color, national origin, religion, sex, gender identity, including gender expression, sexual orientation, disability, age, marital status, family parental status, income derived from a public assistance program, political beliefs, or reprisal or retaliation for prior civil rights activity in any program or activity conducted or funded by USDA. Not all bases apply to all programs. Remedies and complaint filing deadlines vary by program or incident. Program information may be made available in languages other than English. Persons with disabilities who require alternative means of communication to obtain program information, for example, Braille, large print, audio tape, or American Sign Language, should contact the responsible mission area, agency, or staff office, the USDA Target Center at 202-720-2600, or the Federal Relay Service at 1-800-877-8339. The objective of today's training is to provide a broad overview of civil rights and equal opportunity laws that apply to NIFA employment practices and NIFA-funded programs and activities. We'll start with the Civil Rights Act of 1964. There are many different titles and effects that these titles have had, but today we'll be discussing Title VI and Title VII, again to focus on civil rights and equal opportunity laws that apply to NIFA employment situations, as well as NIFA-funded programs and activities. Title VI of the Civil Rights Act prohibits discrimination on the basis of race, color, and national origin in any federally financially assisted program or activity. Federal financial assistance can include grants and loans of federal funds, grants of federal property, detail of federal personnel, use of federal equipment, and donations of surplus federal property. That is to say that generally, while we think of federal financial assistance as grants that are awarded to carry out programs and activities, there are other types of financial assistance from the federal government that can obligate compliance by a recipient to Title VI of the Civil Rights Act. Also, it's important to note that the definition of program or activity under Title VI includes all of the operations of an administrative unit of an entity when any part of that unit receives federal financial assistance. In other words, if a College of Agriculture receives a research grant, all of the programs or activities of that college are covered by Title VI, not just the research that is conducted under the grant. In 2000, after significant case law around the issue, Executive Order 13166 clarified that individuals with limited English proficiency, or LEP, are covered under Title VI's prohibition against discrimination based on national origin. This means that recipients of federal financial assistance, including recipients of NIFA financial assistance, are required to provide language access services, such as translations of vital written documents, as well as professional interpretation services to LEP individuals free of charge. Moving on to Title VII of the Civil Rights Act. This law prohibits discrimination in employment based on race, color, religion, sex, or national origin. It applies not only to federal government, but also to private sector employers. And it protects applicants for employment as well as employees. Title VII also requires that employers reasonably accommodate sincerely held religious practices, unless doing so would impose an undue hardship on the operation of the employer's business. The Pregnancy Discrimination Act amended Title VII to make it illegal to discriminate against a woman in employment because of pregnancy, childbirth, or a medical condition related to pregnancy or childbirth. The Pregnancy Discrimination Act applies to any aspect of employment, including hiring, firing, pay, job assignments, promotions, layoffs, training, fringe benefits such as leave and health insurance, and any other term or condition of employment. The Equal Pay Act is an amendment to the Fair Labor Standards Act that applies to all employers. This act makes it illegal to pay different wages to men and women if they perform equal work in the same workplace. All forms of compensation are covered, including salary, overtime pay, bonuses, life insurance, vacation and holiday pay, cleaning or gasoline allowances, hotel accommodations, reimbursement for travel expenses, as well as benefits. If there isn't inequality in wages between men and women who perform substantially equal jobs, employers must raise the wages to equalize pay, but may not reduce the wages of other individuals. Title IX of the Education Amendments Act is a comprehensive federal law that prohibits discrimination on the basis of sex in any federally funded educational program or activity. In addition to traditional educational institutions, such as colleges, universities, and elementary and secondary schools, Title IX also applies to any education or training program operated by a recipient of federal financial assistance. Sexual harassment is one form of sex discrimination that is prohibited under Title IX. Now we're going to discuss two different laws that work in tandem and have very similar requirements. These two laws both relate to non-discrimination and equal opportunity for individuals with disabilities. And we're going to discuss these two laws together. The first one is the Rehabilitation Act. And we're going to focus on Section 501, Section 504, and Section 508 of the Rehabilitation Act. The other law that applies to non-discrimination and equal opportunity for individuals with disabilities is the Americans with Disabilities Act. And we are going to discuss Title I and Title II of the Americans with Disabilities Act. First, it's important to note that both the Americans with Disabilities Act and the Rehabilitation Act protect qualified individuals with disabilities. An individual with a disability is defined under these laws as a person who has a physical or mental impairment that substantially limits one or more major life activities, someone who has a record of such an impairment, or someone who is regarded as having such an impairment. These laws also prohibit certain kinds of discrimination against individuals due to their association with an individual with a disability. First, Section 501 of the Rehabilitation Act prohibits federal agencies from discriminating in employment against qualified individuals with disabilities. Section 501 also requires federal agencies to take affirmative action in the hiring, placing, and advancing of individuals with disabilities. EEOC, the Equal Employment Opportunity Commission, interprets Section 501's affirmative action mandate for federal agencies by setting employment goals for federal agencies for individuals with disabilities. Section 501 also requires federal agencies to provide reasonable accommodations for individuals with disabilities unless the accommodations would cause undue hardship. A reasonable accommodation is any change in the work environment or in the way a job is performed that enables a person with a disability to enjoy equal employment opportunities. Title I of the Americans with Disabilities Act expands the prohibitions of Section 501, which we just discussed, to cover discrimination against individuals with disabilities in employment in the private sector and in state and local governments, because remember, Section 501 specifically applied to federal employment. Like Section 501, Title I prohibits discrimination against individuals with disabilities in job application procedures, hiring, firing, advancement, compensation, job training, and other terms, conditions, and privileges of employment. Title I requires employers to reasonably accommodate the known physical or mental limitations of an otherwise qualified individual with a disability who is an applicant or employee, unless doing so would impose an undue hardship on the operation of the employer's business. Section 504 of the Rehabilitation Act prohibits discrimination against individuals with disabilities in programs receiving federal financial assistance. This includes a requirement that recipients provide individuals with disabilities with equally effective opportunities to benefit from services and benefits, and that services and benefits be provided in the most integrated setting possible. Section 504 of the Rehabilitation Act requires recipients to provide reasonable accommodations and/or reasonable modifications for individuals with disabilities, unless doing so would fundamentally alter the nature of the program or the activity. Section 504 also requires recipients of federal financial assistance to provide equally effective communications to individuals with disabilities free of charge. Title II of the Americans with Disabilities Act requires that state and local governments and their instrumentalities give people with disabilities an equal opportunity to benefit from all of their programs, services, and activities. Title II applies to all public universities. Just as we saw with Title I and Section 501, Title II of the ADA extends Section 504's requirements, including those regarding reasonable accommodations, integrated settings, and equally effective opportunities and communications to all public services, regardless of whether they receive federal financial assistance. Section 508 of the Rehabilitation Act requires federal agencies to develop, procure, maintain, and use information and communications technology that is accessible to individuals with disabilities. Section 508 includes, for example, making information on public-facing federal web pages accessible to individuals using screen readers. The U.S. Access Board established the Section 508 standards that implement the law and provides the requirements for accessibility. The Age Discrimination and Employment Act protects people who are 40 or older from discrimination and employment because of their age. The law prohibits discrimination in any aspect of employment, including hiring, firing, pay, job assignments, promotions, layoffs, training, benefits, and any other term or condition of employment. It is also illegal to harass an individual because of their age. The Age Discrimination Act, not to be confused with the Age Discrimination and Employment Act that we just discussed, prohibits discrimination on the basis of age in programs that receive federal financial assistance. Unlike the Age Discrimination and Employment Act, the Age Discrimination Act does not target a specific age group. Individuals of various ages are protected from discrimination. That said, age distinction is permitted if it is necessary for the normal operation of the activity or program. The Genetic Information Non-Discrimination Act prohibits discrimination against employees or applicants because of genetic information. It also prohibits the use of genetic information in making employment decisions and restricts employers from requesting, requiring, or purchasing genetic information. Genetic information under this act is defined to include information from genetic tests as well as information about family medical history. Finally, it's important to note that all of the laws that we've discussed today prohibit adverse action against individuals who exercise their rights under these laws. This means that any individual who files a discrimination complaint, raises a concern about a potentially discriminatory act, or participates in an investigation under civil rights laws cannot endure negative consequences as the result of doing so. Explicitly prohibiting retaliatory acts is an important part of all civil rights policies. Finally, I would like to provide everyone with contact information for equal opportunity staff, myself, our EEO specialist, Teresa Murray, as well as the Director of Equal Opportunity Staff and Civil Rights, Ms. Strenda Williams. I would also like to draw your attention to the fact that we have various civil rights resources available on the NIFA USDA page, including several civil rights webinars with slide decks from the PowerPoint presentations, as well as recordings of civil rights trainings on that various topics, including going more in depth on some of the laws that I mentioned today and how they apply and examples of what they require. If you would like to check that out, the password for opening those webinars, you will receive a prompt asking for a password, and the password is equal opportunity, one word, capital E, capital O. Thank you so much for joining this presentation and learning about civil rights laws.